The National Sunday Law, Part 5. We will begin at page 141. Senator Blair: Do you know whether this young man had money or friends? Mr. Jones: Dr. Lewis, can you certify whether he had money? Dr. Lewis: The case was never reported to other churches for relief. I do not know as to his personal estate. Senator Blair: Do you not think it was a peculiar man who would allow his child to be killed and his wife to starve? Dr. Lewis: The case was not reported to our churches in the North. Mr. Jones: About the peculiarity, I will say that John Bunyan stayed 12 years in Bedford jail when he could have got out by simply saying the word yes and agreeing that he would not preach. Senator Blair: It was a very different thing to be called on to say that he would abstain from the performance of a great duty in his church. He preached the gospel, and he would not agree not to preach the gospel. But here is a man who lets his wife and child die rather than pay $25 or $50 and get out and have an opportunity to go to work for them. Mr. Jones: What kind of law is that which puts a man upon his conscience to choose between his wife and child and paying a fine of $25 or $50? But suppose he had paid the fine and got out and gone to work again, how long could he have worked? When the next Sunday came around, it was his duty to his wife and child to work for their support. Is he to go to work on Sunday and go through the course of prosecution again and again, pay a fine of $25 or $50? How long could this be kept up? There are not many poor farmers who can clear from $25 to $50 every week, above all expenses, to be devoted to paying regular fines for the privilege of following their honest occupation on their own premises. But it will be said, let him not work on Sunday, then he would not have to pay a fine. Well, if he consents to do no work on Sunday, he consents to be robbed of the 1/6 of his time, which he honestly owes to the support of his wife and child. For to rob him of 1/6 of his time is precisely what the state does in such a case. And it is either confiscation outright or confiscation under the guise of a fine imposed as punishment for his refusing to allow himself to be robbed of 1/6 of his time. Either this or else he must give up his right to worship God according to the dictates of his own conscience and the word of God, and so surrender his rights of conscience altogether. It comes to this, therefore, that Sunday laws are a direct invasion of the rights of conscience. More than this, Sunday laws are a direct invasion not only of the constitutional right, but the inalienable right of acquiring, possessing, and protecting property. I here adopt the language of the Supreme Court of California, language which can never be successfully controverted. The right to protect and possess property is not more clearly protected by the Constitution than the right to acquire. The right to acquire must include the right to use the proper means to attain the end. The right itself would be impotent without the power to use the necessary incidents. If the legislature have the authority to appoint a time of compulsory rest, it is without limit and may extend to the prohibition of all occupations at all times. For the Constitution to declare a right inalienable and at the same time leave the legislature unlimited power over it would be a contradiction in terms, an idle provision, proving that a constitution was a mere parchment barrier, insufficient to protect the citizens, delusive and visionary, and the practical result of which would be to destroy, not conserve, the rights which they may assume to protect. The legislature, therefore, cannot prohibit the proper use of the means of acquiring property except the peace and safety of the state require it. But does the peace and safety of the state require it in any such case as is here involved? Can it ever be against the peace and safety of the state for any man to follow his honest, legitimate, and even laudable occupations? It is against the peace and safety of the state to prohibit it. For as I have before conclusively proved, For the state to do so is for it to put honest occupations in the catalogue of crimes, to put peaceable and industrious citizens upon a level with criminals, and to put a premium upon idleness and recklessness. It is certainly against the peace and safety of any state to do any such thing. Therefore, it is demonstrated that Sunday laws are an invasion of the inalienable right of acquiring and possessing property, and for that man in Arkansas to have obeyed that law would have been to surrender his inalienable right. Once more, as the right to acquire property includes the right to use the proper means to attain that end, and as such a law deprives a man of the use of such means during the 1/6 of his time, it follows that it is a violation of that provision of the 14th Amendment of the United States Constitution, which declares that no state shall deprive any citizen of life, liberty, or property without due process of law. All this, sir, is involved in the question as to whether that man shall recognize the law to such an extent as even to pay the fine. If he does, then it follows inevitably that all his property shall go to pay fines, or else he must choose between yielding his rights of conscience and allowing 1/6 of his time to be confiscated, and in that certain proportion of property, because to the industrious citizen time is property. But if the state by a Sunday law or by any other means may confiscate a part, it may confiscate all. Where then shall resistance to oppression begin? I say, at the very first appearance of it. Under cover of the word loan, Charles I undertook to confiscate a small sum of money from each of the property owners of England. John Hampden's share was about $7.75. He was a rich man, but he refused to pay it, and his refusal to pay that paltry sum led to all England's being plunged into confusion and civil war. The king lost his head. Hampden himself lost his life, and all this rather than to pay the insignificant sum of $7.75, less than 1/3 of the fine imposed upon this man for refusing to assent to the confiscation of 1/6 of his property. But John Hampden's refusal to pay that money established the constitutional principle that every man has the inalienable right to acquire, possess, and protect property, a right which was invaded in this case. Upon this principle alone, that man was entirely justified in refusing to pay the fine imposed by that Sunday law. But as there was also involved the inalienable right of conscience, he was doubly justified in refusing to obey the law or to recognize the principle. Senator Blair, suppose he was a guilty man. Suppose he did not believe it was an offense to steal, and that he conscientiously thought that he could take goods from another in a certain way. He had been convicted under the law and was under the penalty of paying $25 fine. Is he to put his right of conscience against the demands of wife and child, and against the judgment of the community and the state in which he lives, and to which he owes all the rights to the enjoyment of property and everything else he has? In this case, a man saw all this evil done rather than pay $25 or $50, and he says he did that by reason of his conscience. Mr. Jones, the cases are not parallel at all, unless indeed you count it as much of a crime for a man to follow his honest occupation as it is for him to steal. This, however, we have demonstrated is the very thing that Sunday laws do. But we forever protest against honest industries being put upon a level with thieving. The man who steals takes the property of others without compensation and without regard to the question of right. If then the state takes from him property or time without compensation, he cannot complain of injustice. But in the case of the man who works on Sunday, he invades no man's right in any degree. He takes no man's property or his time in any way, much less does he take it without compensation. For the state to punish the thief is just. For the state to punish the industrious citizen is preeminently unjust. But aside from all this, did you ever hear of a man whose conscience taught him that it was right to steal, that it was a conscientious conviction to steal? Senator Blair, I have heard of great many instances where an individual confessed that he had conscientiously violated the law, yet he was punished. Mr. Jones, precisely, and the Christians were put to death under the Roman Empire for violating the law. Senator Blair, but Senator Blair, but that does not answer my question, and it is not necessary that it should be answered. Mr. Jones, it is right for any man. Mr. Jones, is it right for any man to violate any law that invades his constitutional rights, and it is his right conscientiously to violate any law that invades the rights of conscience? God declares the man innocent who violates the law that interferes with man's relationship to God, the law that invades the rights of conscience. See cases the king versus Shadrach, Meshach, and Abednego, and the state versus Daniel, reported in Daniel chapters 3 and 6. The end of the Arkansas case, as reported by Senator Crockett, was that the poor man lost both his wife and his child. Senator Blair, what became of him? Mr. Jones, he left the state. Senator Blair, I should think he ought to leave it. Mr. Jones, so do I, sir. But what can be said of freedom any more in this country when such things can be? That is also true of 6 other men who follow the dictates of their own consciences as good, honest, virtuous citizens as lived in Arkansas. Senator Blair, there is a good deal of humbug about the dictates of one's own conscience. If a man is to set up his conscience against the obligations to do what is right and to perform his duty toward society, an unintelligent and uninformed conscience of that kind might be allowed to destroy all society. It is not conscience always. Mr. Jones, I beg your pardon, sir. The rights of conscience are eternally sacred. There is no conscience in regard to the state, however. Conscience has to do with God and with what he has commanded, and a man reads in the Bible what God commands. I here adopt the words of the present Associate Justice of the Supreme Court of the United States, Honorable Stanley Matthews, in his speech in the case of the Cincinnati School Board versus Minor et al. He says, we may call the eccentricities of conscience vagaries, if we please. Let me read this again. We may call the eccentricities of conscience vagaries, if we please, but in matters of religious concern, we have no right to disregard or despise them, no matter how trivial and absurd we may conceive them to be. In the days of the early Christian martyrs, the Roman lictors and soldiers despised and ridiculed the fanaticism that refused the trifling conformity of a pinch of incense upon the altar erected to the Caesar, that arrogated to himself the title and honor of divine or of a heathen statue. History is filled with the record of bloody sacrifices which holy men who feared God rather than men have not withheld on account of what seemed to cruel persecutors, but trifling observances and concessions. Conscience, if your honors please, is a tender thing, and tenderly to be regarded, and in the same proportion in which a man treasures his own moral integrity, sets up the light of conscience within him as the glory of God shining in him to discover to him the truth, so ought he to regard the conscience of every other man, and apply the cardinal maxim of Christian life and practice. Whatsoever ye would that men should do to you, do ye even so unto them. Senator Blair, should those who conscientiously believe in free love be allowed to indulge in it? Mr. Jones, there is no point in that. Where there is any conscientious convictions in free love, I cannot discover it. There is no room for any. Senator Blair, but there must be laws which prohibit immorality. Mr. Jones, I ask you to define what immorality is, and then I will answer your question. Senator Blair, if you do not know what the expression means, I shall not undertake to enlighten you. Mr. Jones, I know what it means. Senator Blair, then why do you ask me to define it? Why do you not answer the question? Mr. Jones, because there are modified meanings of the word which make it refer to crime. Immorality is itself a violation of the law of God, and civil government has no right to punish any man for a violation of the law of God as such. I do say, therefore, that which, properly speaking, is immorality, the civil law cannot prohibit, and that it has no right to attempt it. Morality is defined as follows. Morality, the relation of conformity or nonconformity to the true moral standard or rule, the conformity of an act to the divine law. As morality is the conformity of an act to the divine law, it is plain that morality pertains solely to God, and with that civil government can have nothing to do. Again, moral law is defined as the will of God as the supreme moral ruler concerning the character and conduct of all responsible beings, the rule of action as obligatory on the conscience or moral nature. The moral law is summarily contained in the Decalogue, written by the finger of God on the 2 tables of stone and delivered to Moses on Mount Sinai. These definitions are evidently according to Scripture. The Scriptures show that the 10 Commandments are the law of God, that they express the will of God, that they pertain to the conscience and take cognizance of the thoughts and intents of the heart, and that obedience to these commandments is the duty that man owes to God, says the Scripture. Fear God and keep his commandments, for this is the whole duty of man. Ecclesiastes 12 verse 13. And the Savior says, Ye have heard that it was said by them of old time, Thou shalt not kill, and whosoever shall kill shall be in danger of the judgment. But I say unto you that whosoever is angry with his brother without a cause shall be in danger of the judgment. And whosoever shall say to his brother, Raka, which means vain, fellow, shall be in danger of the council. But whosoever shall say, Thou fool, shall be in danger of hellfire. Matthew 5 verses 21 and 22. The Apostle John, referring to the same thing, says, Whosoever hateth his brother is a murderer. 1 John 3:15. Again, the Savior says, Ye have heard that it was said by them of old time, Thou shalt not commit adultery. But I say unto you that whosoever looketh on a woman to lust after her hath committed adultery, and her already hath committed adultery with her already in his heart. Matthew 5 verses 27 and 28. Other illustrations might be given, but these are sufficient to show that obedience to the moral law is morality, that it pertains to the thoughts and intents of the heart, and therefore in the very nature of the case lies beyond the reach or control of the civil power. To hate is murder, to covet is idolatry, to think impurely of a woman is adultery. These are all equally immoral and violations of the moral law, but no civil government seeks to punish for them. A man may hate his neighbor all his life. He may covet everything on earth. He may think impurely of every woman that he sees. He may keep it up all his days. But so long as these things are confined to his thought, the civil power cannot touch him. It would be difficult to conceive of a more immoral person than such a man would be, yet the state cannot punish him. It does not attempt to punish him. This demonstrates again that with morality or immorality, the state can have nothing to do. But let us carry this further. Only let that man's hatred lead him, either by word or sign, to attempt an injury to his neighbor, and the state will punish him. Only let his covetousness lead him to lay hands on what is not his own in an attempt to steal, and the state will punish him. Only let his impure thought lead him to attempt violence to any woman, and the state will punish him. Yet bear in mind that even then the state does not punish him for his immorality, but for his incivility. The immorality lies in the heart, and can be measured by God only. The state punishes no man because he is immoral. The The state punishes no man because he is immoral. If it did, it would have to punish as a murderer the man who hates another, and to punish as an idolater the man who covets, and to punish as an adulterer the one who thinks impurely, because according to the true standard of morality, hatred is murder, covetousness is idolatry, and impurity of thought is adultery. Therefore, it is clear that in fact the state punishes no man because he is immoral, but because he is uncivil. It cannot punish immorality, it must punish incivility. This distinction is shown in the very term by which is designated state or national government. It is called civil government. No person but a theocrat even ever thinks of calling it moral government. The government of God is the only moral government. God is the only moral governor. The law of God is the only moral law. To God alone pertains the punishment of immorality, which is the transgression of the moral law. Governments of men are civil governments, not moral. The laws of states and nations are civil laws, not moral. To the authorities of civil government pertains the punishment of incivility, that is, the transgression of civil law. It is not theirs to punish immorality. That pertains solely to the creator of the moral law and of the moral sense, who is the sole judge of man's moral relation. All this must be manifest to everyone who will think fairly upon the subject, and it is confirmed by the definition of the word civil, which is this: civil, pertaining to a city or state, or to a citizen in his relation to his fellow citizen, or to the state. Thus it is made clear that we owe to Caesar, or civil government, only that which is civil, and that we owe to God that which is moral or religious, and that to no man, to no assembly or organization of men, thus there belong any right whatever to punish immorality. Whoever attempts it usurps the prerogative of God. The Inquisition is the inevitable logic of any claim of any assembly of men to punish immorality, because to punish immorality it is necessary in some way to get at the thoughts and intents of the heart. The papacy, asserting the right to compel men to be moral and to punish them for immorality, had the cruel courage to carry the evil principle to its logical consequence. In carrying out the principle, it was found to be essential to get at the secrets of men's hearts, and it was found that the diligent application of torture would wring from men in many cases a full confession of the most secret counsels of their hearts. Hence, the Inquisition was established as the means best adapted to secure the desired end. So long as men grant the proposition that it is within the province of civil government to enforce morality, it is to very little purpose that they condemn the Inquisition, for that tribunal is only the logical result of the proposition. Thus much on the subject of morality and the state in the true and genuine sense of the word morality. But as I said at the beginning, there is an accommodated sense in which the word morality is used, in which it is made to refer only to men's relations to their fellow men, and with reference to his view of morality, it is sometimes said that the civil power is to enforce morality upon a civil basis, but morality on a civil basis is only civility, and the enforcement of morality upon a civil basis is the enforcement of civility and nothing else. Without the Inquisition, it is impossible for civil government ever to carry its jurisdiction beyond civil things or to enforce anything but civility. But it may be asked thus that civil power enforce the observance of the commandments of God, which say, Thou shalt not steal, thou shalt not kill, thou shalt not commit adultery, and thou shalt not bear false witness. Does not the civil power punish the violation of these commandments of God? I answer, the civil power does not enforce these, nor does it punish the violation of them as commandments of God. The state thus forbid murder and theft and perjury, and some states forbid adultery, but not as commandments of God. From time immemorial, governments that knew nothing about God have forbidden these things. If the state is to enforce these things as the commandments of God, it will have to take cognizance of the thoughts and intents of the heart, but this is not within the province of any earthly power. By all these evidences is established the plain common sense principle that to civil government pertains only that which the term itself implies, that which is civil. The purpose of civil government is civil and not moral. Its function is to preserve order in society and to cause all its subjects to rest in assured safety by guarding them against all incivility. Morality belongs to God, civility to the state. Morality must be rendered to God, civility to the state. Immorality must be punished, can be punished only by the Lord. Incivility must be punished, and no more than that can possibly be punished by the state. Here, then, at the close of my remarks, we are brought to the enunciation of the eternal principle with which I began, upon which we now stand, and upon which we forever expect to stand, the principle embodied in the United States Constitution forbidding religious tests and forbidding Congress to make any law respecting an establishment of religion or prohibiting the free exercise thereof. The principle established by Jesus Christ: render therefore unto Caesar the things which are Caesar's, and unto God the things that are God's. Dr. Lewis: Mr. Chairman, the objection raised by Professor Jones against the exemption in favor of Sabbath keepers seemed to me wholly imaginary. So far as any Seventh-day Baptists are concerned, I know it would be impossible for any man opening a saloon on Sunday to present the excuse that he was a Seventh-day Baptist. A saloon-keeping Seventh-day Baptist is an unknown thing throughout their history of more than 2 centuries. Such a man could not obtain recognition, much less church membership, in any Seventh-day Baptist community or church. Nor do I believe, from what I know of the Seventh-day Adventists, that such a case could occur in connection with that people. The possibility of any such deceitful claim could easily be guarded against by a provision requiring that in any case of doubt, the one claiming to have observed the seventh day would be required to bring official certificate of his relation to a Sabbath-keeping church. Such a provision would end all difficulty. Mr. Jones: Mr. Chairman, it is certainly true that, so far, a saloon-keeping Seventh-day Baptist or Seventh-day Adventist either is an unknown thing, but if Sunday laws are enforced with an exemption clause in favor of those who keep the seventh day, this would not be an unknown thing much longer. It is true also that such a man could not obtain a membership in any Seventh-day Baptist or Seventh-day Adventist church. But what is to prevent the saloon keepers from organizing Seventh-day Baptist or Seventh-day Adventist churches of their own and for themselves? What is to prevent them or any class of businessmen from organizing their own churches, electing their own officers, and even ordaining their own pastors and calling themselves Seventh-day Baptists or Seventh-day Adventists? There is nothing to prevent it, unless indeed the state itself shall take charge of all seven-day churches and doctrines and attend to their organization and the admission of members. This is precisely what was done before. In the days of the New England theocracy, Massachusetts enacted a law that from time to come, no man shall be admitted to the freedom of this body politic, but such as are members of some of the churches within the limits of the same. There were considerable numbers of men who were not members of any of the churches who could not be, because they were not Christians. These men then took to forming themselves into churches of their own. Then the next step for the authorities to take, and they took it, was to enact a law that, forasmuch as it had been found by sad experience that much trouble and disturbance hath happened both to the church and civil state by the officers and members of some churches, it is which have been gathered is an undue manner, it is ordered that this court doeth not nor will hereafter approve of any such companies of men as shall henceforth join in any pretended way of church fellowship without they shall first acquire, sorry, let me read this, it's an old English. Then the next step for the authorities to take, and they took it, was to enact a law that, quote, forasmuch as it hath been found by sad experience that much trouble and disturbance hath happened both to the church and civil state by the officers and members of some churches which have been gathered is an undue manner, it is ordered that this court doeth not, nor will hereafter approve of any such companies of men as shall henceforth join in any pretended way of church fellowship without they shall first acquaint the magistrates and elders of the greater part of the churches in this jurisdiction with their intentions and have their approbation herein. Taken from Emancipation of Massachusetts, pages 28 to 30. By this, gentlemen, you will see the enactment of this Sunday law, though the first step will not be by any means the last step, and that in more directions than one, their offer of the exemption clause is a voluntary confession that the enforcement of the law without one would be unjust. But if the exemption clause be embodied and maintained, the state is inevitably carried beyond its proper jurisdiction, and if the exemption clause is retained and not maintained in its strictness, the whole law is at once nullified. Congress would better learn wisdom from the prospect and utterly refuse to have anything at all to do with the subject. The whole subject is beyond the jurisdiction of the civil power, and the civil power can do no better than to let it entirely alone. But Dr. Lewis proposes to guard against all difficulty by requiring every observer of the seventh day to bring official certificate of his relation to a Sabbath-keeping church. This would not end the difficulty, for as I have shown, it would inevitably devolve upon the state to decide what was genuine Sabbath-keeping church. But that is not the worst feature in this suggestion. If Dr. Lewis officially represents the Seventh-day Baptist denomination and for the denomination proposes thus voluntarily to put himself and all his people on ticket of leave, I have no particular objection. That is their own business. Yet it seems to me an extremely generous proposition, if not an extraordinary proceeding. I say they may do this if they choose. But as for me and for the Seventh-day Adventists generally, not only as Christians but as American citizens, we repudiate with scorn and reject with utter contempt every principle of any such suggestion. As citizens of the United States and as Christians, we utterly and forever refuse to put ourselves upon ticket of leave by any such proposition. Note that my argument first was not so unfounded nor so wholly imaginary as Dr. Lewis supposed, has been conclusively demonstrated even to himself since this hearing was held. The Pearl of Days column of the New York Mail and Express, the official organ of the American Sunday Union in March 1889, gave the following statement from the Plainfield, New Jersey Times. No date. As a rule, Plainfield, New Jersey is a very quiet city on Sunday. Liquor provision, and cigar stores are closed by the enforcement of a city ordinance. If a resident wants a cigar, he will either have it given to him by one of the many pharmacists who refuse to sell on Sunday, or he will go to the two dealers who are allowed to open their places on Sunday because they observe Saturday as their Sabbath. Some time ago, a man of Catholic faith who had an eye to Sunday business in that line became a regular attendant of the Seventh-day Baptist Church. Eventually, he asked to be admitted into the fellowship of the church. A member of the official was only working for business ends. He was closely examined by the church officers, and he finally admitted that he wanted to open a cigar store and do business on Sunday. The man appeared at the wrong place for aid in carrying out his mercenary purposes. He was not received into membership. It looks somewhat like the irony of fate that this thing should fall to the very people whom Dr. Lewis represented, and in the very town where Dr. Lewis himself lives. Remarks by Mrs. J.C. Batham. Mrs. Batham, I should like to say that the point which was I should like to say that the point which has been made was a point carefully considered by the Women's Christian Temperance Union, and we saw the danger. Yet we wished to be exceedingly fair. I consulted 9 persons of different classes of Seventh-day people to know whether they wished such an exemption and whether they would be satisfied with what was proposed. They represented themselves as being in approval of some such provision as has been suggested, and we thought it could be done perhaps in such a way as to afford them the exemption which they desire, because they said that such an exemption is necessary. Senator Blair: Let me ask you a few questions, Mrs. Batham, to see if the Women's Christian Temperance Union understood exactly the relation of what they propose to do in this legislation. Here is a bill which relates to interstate commerce, to postal work, to the Army, and to the Navy. It relates to the subject matter which is carved out of the independent, full jurisdiction of a nation by the states which were once complete sovereignties and transferred to the general government. The occupations I have mentioned are all of public nature, and to carry them on, the nation has such an opportunity to invade the Sabbath rest laws of every state in such a way as to nullify them. The nation at large is unrestrained by any Sabbath law whatever. If it may carry on its post office business on the Sabbath, it may go to any extent, and it does go already to a very great extent, and an increasingly great extent. So in regard to interstate commerce, and so with the Army and the Navy. Now you go to our Seventh-day Baptist or Seventh-day Adventist friends, for instance, and propose to introduce a principle by which they carry on the post office department on the Sabbath just as completely as they see fit. In other words, you propose to exempt them from the operation of the law so far as it prohibits post office work on the Sabbath. Suppose you have a Seventh-day Baptist man for postmaster. Suppose you fill up every post office in the country on the Sabbath with Seventh-day Baptist people. You have the post office department in operation by virtue of this exemption, because they can do the work conscientiously on that day. If you limit it by saying the bill shall not apply to the Adventists and others, the bill provides that already. Mrs. Batham: If you remember the clause, we do not propose to provide that they shall be able to do this work, but that they shall be exempt from the penalty. They are not allowed to do the work, but they are to be exempt from the penalty. Therefore, unless they could prove that they had not done the work to the disturbance of others, it would be impossible for them to carry on post office matters, for instance, or any other public employment on Sunday. Senator Blair: Is it not equivalent to saying that if the penalty shall not be enforced against them, there shall be no law against them? Because the law without the penalty is simply an opinion, it is not a law. Mrs. Batham: The law could provide that they should not open a post office, for instance, or any place of business, and if there was fine imposed, they would be compelled to close such places on Sunday. It was, of course, only thrown out as suggestion from us that, if it could be done, we should like to have such a provision in the bill. We are satisfied that people want the law, and if the law can, in your wisdom, be arranged with such an exemption, then we wish it. Otherwise we do not. We are all glad, I think, to have the gentlemen admit that they do not want such an exemption, for that releases us from the place where we were. Senator Blair: This is not to be a general Sunday law. These people all live in states, and they can work at their private occupations just the same under similar amendments to the state law, if the state law fit to make such amendments. Professor Jones says it did not work well in Arkansas, and I should think it did not from his description, but these are public occupations, or quasi-public occupations we are dealing with. That of interstate commerce, for instance, carried on by great corporations, which are public in their relation to the working men, because they are exercising a great public function in carrying on transportation which pertains to everybody all over the country. This proposed law undertakes to prohibit the nullification of all Sunday rest laws in the state so far as to provide that interstate commerce shall not be carried on in violation of the law upon the Sabbath. When you come to the private occupations which are regulated by the states, if they choose to allow the Seventh-day Baptist people to work on Sunday in those private occupations, on the farm, in the workshops, in the factory, this measure does not interfere with them at all. Mrs. Batham, I have not the words before me, but my impression is that there is a clause in the bill providing that the jurisdiction of Congress shall be exercised over the territories in this matter. There is something of that kind in the bill, and this proposed exemption was designed to reach those cases rather than apply to the general governmental action. Senator Blair, you think the exemption might be made with reference to the territories? Mrs. Bateman, yes. That was the point we had in mind in the general action. I have not the words of the bill before me, but there is something of that kind in it which we had in mind. I wish to say also that one of the requests of our National Women's Christian Union was that the word promote should be changed to protect in the title of the bill, so that it should have no appearance of what all Americans object to, any union of church and state. That amendment was proposed and accepted by the American Sabbath Union, the organized body which has just been in session in this city. Senator Blair, do you not think that the word protect implies power to command and compel? An army protects. Mrs. Batham, all our laws protect us, do they not? Senator Blair, you would make this a law? Mrs. Batham, I suggest that the bill be made a law, and that it be a law which shall protect the civil Sabbath, not promote religious worship, but protect the day as the day of rest and religious worship. Senator Blair, it seems to me that the word protect is a stronger and more interfering word than promote. However, all these suggestions are important. Reply. Mr. Jones, Mr. Chairman, Mrs. Batham, in her first address this morning, in telling who they are that are in favor of this Sunday law, said that she believed the great majority of the people will approve such a law. She mentioned as opposed to it only the daily newspaper press, the railroad managers, steamboat companies, saloonists and their backers, a class of foreigners who prefer the Continental Sunday, and the very small sect of Seventh-day Baptists. Honorable G.P. Lord in his remarks said that more than 3 million of our population work on Sabbath, and most of this number are unwilling workers. He said that the balance, or more than 50 million of our population, abstain from toil on the Sabbath. Taking these statements as the truth, it appears that the overwhelmingly majority of the American people are not only in favor of the Sunday law, but they actually keep that day as a rest day. Now, gentlemen, is it not rather singular and a doctrine altogether new in a government of the people that the majority need to be protected? From whom are they to be protected? From themselves, most assuredly, because by their own representation they are so vastly in the majority that it would be impossible for them to be oppressed by anybody else. But in a government of the people, when the majority are oppressing themselves, how can laws prevent it when the laws must be made by the majority, that is, by the very ones who are carrying on the oppression? If to them my argument seems unsound, I would cite entirely for their benefit the words of the Supreme Court of Ohio, that the protection guaranteed in our constitutional provisions means protection to the minority. The majority can't protect itself. Constitutions are enacted for the purpose of protecting the weak against the strong, the few against the many. This is sound sense as well as sound constitutional law. Now, suppose in accordance with this sound constitutional principle, and under cover of their own statements, we, Seventh-day observers, whom they themselves designate as being so entirely in the minority as scarcely to be worthy of recognition, suppose we should come to Congress asking for protection, and, as all my argument has shown, if anybody needs protection in this matter, assuredly it is ourselves. Suppose then we come to Congress asking for protection in the same way that they ask for it. Suppose we should ask Congress to enact a law compelling all people to do no work on Saturday in order to protect us in our right to keep Saturday. What would be thought of that? What would these people themselves think of it? What ought anybody to think of it but that it was a piece of unwarranted assumption of authority to force upon others our ideas of religious observances? What is all it would be? And it would be utterly inexcusable. And I risk nothing in saying that these people themselves, as well as everybody else, would pronounce it unwarrantable and inexcusable. But if that would be so in the case of a minority who actually need to be protected, what then ought not to be thought of these people who claim to be in the overwhelming majority in their mission here, asking Congress to compel everybody to rest on Sunday for their protection? Gentlemen, it is not protection but power that they want. Remarks by John B. Wood. Mr. Wood. Mr. Chairman, as a member of the Society of Friends, a Quaker, I should like to say a few words. I have a great deal of sympathy with people who talk about the right of conscience. I do not think the United States government has any right over conscience. We as Friends deny their right over our consciences while we act in accordance with the revealed will of God, the Bible. In looking at this Sunday question, I see nothing in the Bible. There is no word in it in which it is stated that we shall have to work on the first day of the week. Therefore, I do not think the Seventh-day Baptists have any right to object to the proposed legislation. The only thing they lose is one more day's work out of the week. The Society of Friends has always denied the right to fight. The result has been that in the United States they have never lost a life by that means, not even during the last war. The Lord Jesus Christ has always protected them. I think that any Saturday Baptist who believes honestly that the Sabbath is Saturday can depend upon the Lord's providing for him in 5 days of the week just as well as if he worked 6, and he will have 2 Sundays instead of 1 and be that much better off. Reply, Mr. Jones. In answer to the question raised by Mr. Wood, what conscientious convictions do not require us to work on the first day of the week, one of the 6 working days, I wish to say? First, we deny his right as well as the right of the state to assume the prerogative of deciding for us what the Bible teaches or what our conscientious convictions do or do not require. Secondly, we deny the right of the state to cause us to lose the whole or any part of a day's work out of every week, and I turn this point upon him as I turned it upon the others. Why have we not as much right to ask for a law compelling them to rest on the day that we keep as they have to compel us to rest on the day which they keep? The only thing they would lose is one more day's work out of the week. They could have 2 Sundays instead of 1 and be that much better off. Why is it not as good for them as it is for us? Or is this a benefit reserved solely for those who do not keep Sunday? How this invades the constitutional right of acquiring and possessing property and thus deprive us of property without due process of law, I have already discussed. Thirdly, upon this point I wish to read Judge Cooley's opinion. Mr. Wood, I refer to the Bible. Mr. Jones, the Bible says 6 days shalt thou labor. While I do not insist that this is an absolute command that we shall actually work on the whole 6 days, I do insist that it is a God-given permission and therefore our God-given right to work 6 days of every week, and we deny forever the right of the state to forbid us to do that which, to say the very least, God has given us the express right to do. As this is a matter of legislation and therefore of law, Judge Cooley's opinion is of weight upon the subject. He says, the Jew, and the Seventh-day Christian as well, who is forced to respect the first day of the week when his conscience requires of him the observance of the seventh also, may plausibly urge that the law discriminates against his religion, and by forcing him to keep a second Sabbath in each week unjustly, though by indirection, punishes him for his belief. I have shown, Senator Blair, He says plausibly. That word plausibly indicates that there are some counter-views somewhere. Mr. Jones, as to the exact sense of in which he uses the word plausibly, of course we cannot tell without consulting Mr. Cooley himself, but I do not see why we should put the strongest meaning into the word, especially as farther on he shows that the argument of the seventh-day keeper is unanswerable. I am inclined to think that the judge uses the word there in the sense of fairly, rightly, or feasibly. Next, he says, the laws which prohibit ordinary employments on Sunday are to be defended either on the same grounds which justify the punishment of profanity or as establishing sanitary regulations based upon the demonstration of experience that one day's rest in 7 is needful to recuperate the exhausted energies of body and mind. That is one of the pretended grounds of the petition of this National Sunday Law, but the answer of the Supreme Court of California to that is this. This argument is founded on the assumption that mankind are in the habit of working too much and thereby entailing evil upon society, and that without compulsion they will not seek the necessary repose which their exhausted natures demand. This is to us a new theory and is contradicted by the history of the past and the observations of the present. We have heard in all ages of declamations and reproaches against the vice of indolence, but we have yet to learn that there has ever been any general complaint of an intemperate, vicious, unhealthy, or morbid industry. On the contrary, we know that mankind seeks cessation from toil, from the natural influences of self-preservation, in the same manner and as certainly as they seek slumber, relief from pain, or food to appease their hunger. If we cannot trust free agents to regulate their own labor, its times and quantity, it is difficult to trust them to make their own contracts. If the legislature could prescribe the days of rest for them, then it would seem that the same power could prescribe the hours to work, rest, and eat. And Judge Cooley's answer to it is this. The Supreme Court of Pennsylvania have preferred to defend such legislation on the second ground rather than the first, but it appears to us that if the benefit of the individual is alone to be considered, the argument against the law which he may make who has already observed the seventh day of the week is unanswerable. Senator Blair. But he also holds that for the general, the public good, Sunday laws are constitutional. Mr. Jones. Yes, and to be sustained upon authority, for the next sentence says, but on the other ground, it is clear that these laws are supportable on authority, notwithstanding the inconvenience which they occasion to those whose religious sentiments do not recognize the sacred character of the first day of the week. It is something unusual for a person to undertake to answer an unanswerable argument, but Judge Cooley employs here the only means by which an unanswerable argument can ever be answered, and that is on authority. That is the way the papacy has done it from the days of Pope Zosimus, A.D. 418, who, when asked for the reasons for certain of his arrogant actions, exclaimed, "So it has pleased the Apostolic See." That was a sufficient answer to all inquiries and even to unanswerable arguments. England fastened upon the American colonies the Stamp Act. Our fathers presented unanswerable arguments against it, but the Stamp Act, like Judge Cooley's constitutional Sunday laws, was supportable on authority, and that was enough. England proposed to enforce it, but our revolutionary fathers refused assent on any such method of answering unanswerable arguments, so we refuse our assent to Mr. Cooley's answer to that which he himself pronounces as an unanswerable argument. Senator Blair. It does not follow that there is no unanswerable argument in support of Sunday laws, I take it. Mr. Jones. There is the authority. Senator Blair. There is authority for the Sunday laws. It does not follow because the Sunday laws are supported by authority that therefore there is no sufficient argument upon which to base them. Mr. Jones. What authority is there for Sunday laws? Senator Blair. That is what you have been discussing. But you seem to say that because Sunday laws are supported by authority, it is the only argument in favor of a bad law that there is authority for it. But there may be good authority for the Sunday law. Mr. Jones, that is what is shown here, that there is no good authority for it when it unjustly punishes. Let me read this again. Mr. Jones, that is what is shown here, that there is no good authority for it when it unjustly punishes a man for his belief. There cannot be any good authority for unjustly punishing any man for anything, much less for unjustly punishing him for his belief. Senator Blair, he does not say it is bad, Mr. Jones, but it is bad. Is there any good answer to an unanswerable argument? Now I propose to find out what authority there is for Sunday laws. I before referred to the decision of the Supreme Court of Arkansas, and have shown from a statement of the Committee on Law and Law Reform, of which the members of the Supreme Court were members, that decision was unconstitutional. I have shown that the principal law upon which their decision rested was that of the omnipotence of Parliament. In this, however, the state of Arkansas only followed the decisions of other states. In 1858, the Constitution of California said in Section 4, the free exercise and enjoyment of religious profession and worship without discrimination or preference shall forever be allowed in this state. There was a statute passed by the legislature enforcing the observance of the Christian Sabbath on the first day of the week. A Jew in Sacramento kept his store open on Sunday. He was arrested, convicted, and sent to jail. He sued out a writ of habeas corpus on the ground of the illegality of his imprisonment by reason of the unconstitutionality of the law. The majority of the court sustained the plea by decisions separately written, whose soundness both upon constitutional principles and upon the abstract principles of justice itself can never be successfully controverted. Mr. Stephen J. Field, now Associate Justice of the Supreme Court of the United States, was then a member of the California Court. He rendered a dissenting opinion, taking the same position of the Supreme Court of Arkansas as to the omnipotence of the legislature, and soberly maintaining that the term Christian Sabbath in the act was not a discrimination or preference in favor of any religious profession or worship. He declared that moralists and statesmen, men of science, and distinguished philosophers have pronounced the rule of 1 day's rest in 7 to be founded upon a law of a race, but he omitted to state what scientist or philosopher or moralist or statesman has ever pronounced upon that what law is founded the rule of 2 days rest in 7 for a man who chooses to rest some other day than Sunday. In his written opinion, Mr. Field said that he had found that in 25 states of the Union, Sunday laws had been held to be constitutional. That this is so, there can be no doubt on this subject as on that of blasphemy, which I have already noticed the younger states, both in legislation and judicial decisions, have followed the example of the older states, that these have followed the decisions of the oldest, and the oldest followed the example and the precedents of the colonies, and every one of the colonies had Sunday laws because every one had an established religion. These followed the precedents of the English system, which is wholly a church and state system. The church and state system of England severed itself from the papal rule when Henry VIII renounced allegiance to the Pope and put himself at the head of the Church of England in the place of the Pope. The British system at that time was the papal system. The papal system was established by the mutual craft, flattery, and policy of Constantine and the ambitious bishops of his time when the first Sunday law was enacted. This, in a word, is the genealogy of the Sunday laws of the United States. They belong with an established religion, a union of church and state, and in this country they have been almost universally sustained either upon the British principle of the omnipotence of Parliament or upon the church and state principle of the colonies, of the British government, and of the papacy. The law of Pennsylvania, sustained by the decision referred to by Judge Cooley, was virtually a colonial law, which was a part of the system in which nobody who did not confess and acknowledge one Almighty God to be the creator, upholder, and ruler of the world could be a citizen. The Supreme Court of the New York sustained Sunday laws by at once declaring Christianity to be the established religion of that state. This is based upon Chief Justice Kent's decision before referred to, which cited a law of the colony which declared that the profanation of the Lord's Day was the great scandal of the Christian faith. That decision of Judge Kent's made Christianity the established religion of the state of New York by citing the precedents of the papal institutions of modern Europe and the pagan nations of antiquity. This again proves Sunday laws to belong with established religions, with the union of church and state finding their basis in papal and pagan institutions. In every statute book in America, with scarcely an exception, Sunday laws are found under the head of offenses against religion or offenses against God and religion. This springs naturally from the colonial legislation where each colony deemed itself the special guardian of God and of some particular form of religion. But according to the word of Christ, the civil power has nothing to do with either God or religion, nor with offenses against God or religion. Religion is defined by Webster's as the recognition of God as an object of worship, love, and obedience. Another definition given by the National Reform Association itself is a man's personal relation of faith and obedience to God. Civil government has nothing to do with a man's personal relation of faith and obedience to God. If he has no faith at all and makes no pretension to obedience to God, that is nothing to the civil government. So long as the man conducts himself civilly, neither has civil government anything to do with offenses against God. The Lord himself can attend to that. A man is responsible alone to God for the offenses which he commits against God. Civil government has no business to establish a religion and then make offenses against it criminal, nor has it any business to put itself in the place of God and presume to declare that an offense against the governmental idea of God is an offense against God. How is the civil government to know whether an act offends God or not? The fact of the matter is that just as soon as Sunday laws are investigated at all in the light of truth or justice or law, it is found that they are inseparable from any established religion, inseparable from a union of church and state. This is further shown by a mere glance at the British system as set forth by Blackstone in his chapter on offenses against God and religion. Their profanation of the Lord's Day is classed with such things as apostasy, heresy, reviling the ordinances of the church, nonconformity to the worship of the church, witchcraft, conjuration, enchantment, sorcery, religious imposture such as falsely pretending an extraordinary commission from heaven, adultery as an ecclesiastical offense cognizable by the spiritual court, and such confusion of civil and religious ideas as the punishment of drunkenness as an offense against God and religion. This is the company with which Sunday laws belong. The penalty for apostasy was first burning to death. This fell into disuse after a while. Then the penalty was that for the first offense, the offender should be rendered incapable to hold any office or place of trust. At such legal nonsense as this, the United States Constitution struck a death blow in the clause which declares that no religious test shall ever be required as a qualification to any office or public trust under this government. And by the First Amendment to the Constitution of the United States, this government utterly separated itself from the whole system of offenses against God and religion so long maintained by the British government, by the colonies, and even by many of the states, and which is characteristic of all church and state governments. governments of established religion by declaring that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. This is sound American principle and accords with the word of Jesus Christ. And the effort ought to be throughout this whole nation to lift the constitutions, the legislation, and the jurisprudence of the states up to the level of that of the national constitution. But instead of doing that and so carrying this whole nation bodily onward in the march of liberty, enlightenment, and progress, these people go about to bring down our national system of constitution and laws to the level of that of the states, which is the level of that of the colonies, which is the level of that of the British system, which is the level of that of the papacy, which is the system of paganism under cover of the Christian name. Dr. Eliot here today cited Edgar Athelstan and Alfred in support of Sunday laws, to be sure, and with equal force he can cite these and many others of the Dark Ages in support of tithes to the clergy, the supremacy of the monks in civil affairs, the holy anointing of kings by the Pope, and for any and every other thing that belongs with the papal system. He can carry his Sunday law precedents farther back than that. He can go back to the time of Theodosius and Constantine. He can find, and so can you or anybody else, that as Pontifex Maximus of the old pagan system, Constantine had the plenary power of appointing holy days. He can find that by virtue of this power, Constantine established the first Sunday law of all time in honor of the venerable day of the sun, whose special devotee he was, and also that as bishop of externals of the new pagan system, the papal, which office he assumed by virtue of his political conversion to the political Christianity of his time. He played into the hands of the ambitious bishops by giving them in that Sunday law their coveted use of the power of the state for the furtherance of their aims, to compel men to accept the decrees and submit to the dictates of the church. He and all others will find that this is the literal truth of the origin of Sunday laws. All this is supported by abundance of testimony of undoubted authority, so eminent a divine as Dean Stanley declares plainly that the retention of the old pagan name of Dies Solis, or Sunday, for the weekly Christian festival is owing to the union of pagan and Christian sentiment with which the first day of the week was recommended by Constantine to his subjects, pagan and Christian alike, as the venerable day of the sun. It was his mode of harmonizing the discordant religions of the empire under one common institution. This same mode of harmonizing paganism with Christianity was further illustrated by his imperial coins, bearing on one side the name of Christ and on the other the figure of the Son of God, with the inscription, the unconquerable Son. This confusion of pagan and Christian ideas and practices is what made the papacy, the union of church and state, and the confusion of civil and religious things, from which, with the exception of the government of the United States, the nations have not even yet freed themselves. This, sir, is the authority and the only authority for Sunday laws. Sunday has no basis whatever as a civil institution. It never had any. And the only basis it has or ever had as a religious institution is in that confusion of paganism and Christianity which made the papacy, with all that it is or ever was, as authority for Sunday and as the basis of this legislation. Dr. Johnson here today appealed to the Fourth Commandment, the American Sabbath Union, now in session in the city, and which is working for the passage of this bill, likewise declares the basis of their whole movement to be the Fourth Commandment. It is proper, therefore, to inquire what authority is there for Sunday laws in the Fourth Commandment. As this is a question of legislation and of law, I shall examine it from the standpoint of law. Suppose then that this bill has become a law, and the courts in construing it take judicial cognizance of the Fourth Commandment as the basis of the law. Courts are guided by certain well-established rules in the construction of laws. According to these rules, What would be the result of the judicial construction of such a law upon the basis of the fourth commandment? 1. What a court is to declare the law as written. The fourth commandment written is as follows: Remember the Sabbath day to keep it holy. 6 days shalt thou labor and do all thy work. But the seventh day is the Sabbath of the Lord thy God. In it thou shalt not do any work, thou, nor thy son, nor thy daughter, nor thy manservant, nor thy maidservant, nor thy cattle, nor thy stranger that is within thy gates. For in 6 days the Lord made heaven and earth, the sea and all that in them is, and rested the seventh day. Wherefore the Lord blessed the Sabbath day and hallowed it. That commandment, as written, says, the seventh day is the Sabbath. Consequently, at the very first step, the first day of the week, as declared in the bill, and as these people demand, would be completely shut out. But if any should innocently inquire, the seventh day of what? The commandment itself is ready with an explicit answer. It is the day upon which the Lord rested from the work of creation. In that work he employed 6 days, and the seventh day he rested. And that alone, as Dr. Johnson has said, established the weekly division of time. As those 7 days formed the first week of time, the seventh of those 7 was the seventh day of the week. And that is the seventh day fixed in the commandment. This is confirmed by the scriptures throughout. The New Testament itself declares that the Sabbath is passed before the first day of the week comes. Mark 16 verses 1 and 2 says, And when the Sabbath was past, Mary Magdalene and Mary the mother of James and Salome had brought sweet spices that they might come and anoint him. And very early in the morning, the first day of the week, they came unto the sepulchre at the rising of the sun. Those people mentioned in the scripture came to the sepulchre very early in the morning of the first day of the week, yet the Sabbath was past. This National Sunday Bill, which is here under discussion, proposes to secure the religious observance of the Sabbath on the first day of the week. But such a thing can never be done, because according to the scripture, the Sabbath is past before the first day of the week comes. It matters not how early persons may come to the first day of the week and its observance, they will be too late to find the Sabbath in it, because by the word of the Lord it is past before the first day of the week comes. And we will stop the reading of the book here. For our next episode, we will begin at page 175.